Hello everyone. Now let's continue with the next part of your Industrial Dispute Act 1947. Now in this, as I told you earlier, I am going to now discuss about the definition. The first definition we are going to understand is your term industry as per section 2J. Now industry, this term is nothing but it is defined as a business, trade, undertaking, manufacturing, or calling it employees, employers, and includes and calling service and employment, handicraft or industrial occupation or avocation of workmen is known as nothing but simply an industry. Basically everything, a service sector, a manufacturing sector, everything has been covered under the definition of your industry. Now, when I am talking about the definition, the next part is your definition on the part of workman. Now, workman means any person, including an apprentice employment, that is a time being skilled employment, unskilled employment, technical or operational, clerical or supervisory work, or hired on for a reward, whether the term of employment is expressed or implied for a purpose for any proceedings under this act in relation to industrial dispute, where dismissed, discharged or retrenched, connection as to the consequences of the dispute or disposal or discharge, retrenchment has led to any dispute, all that is going to be covered under the term of your workman. Now, but specifically when we are going to say, in general we can say every person is been including in the definition of your workman. But what is not included is more important. In that, firstly, whoever is being appointed under your Air Force Act of 1950, your Navy, your Army, all these defense forces are not been included in the term of workman. Any person who is employed in police services or an officer or other employee of a prison is not going to be called to be as a workman. Now, who is employed mainly in managerial and administrative capacity is also not going to be called to be as a workman. So that's why that is the reason any person working in the offices and companies and all, they are not to be called to be as a workman, but they are called to be as employees. Now, again, who being an employed in the service in supervisory capacity draws wages exceeding 1,600 rupees per month either by nature of his duties attached to the office or by reason of the power invested in him, functions mainly on the managerial nature, cannot be called to be as a workman. So simply these four persons are not to be included in the definition of your workman. The next and the most important term is strike as per section 2Q. Now, as per the section 2Q, strike means a cessation of work by a body of person employed in the industry acting in combination of concerned refusal to work under the industry or undertaking of any person can be called to be as going on the work or not coming continuously on the work can be going on to be called as a strike. Or simply the term is cessation of work, where the cessation of work is very important, where the person purposely is not ready to come for work is going to be called to be as a strike. अभी हमेशा याद रखना, स्ट्राइक वर्कर्स करते हैं, बट जब एम्प्लॉयर्स जब काम नहीं देते तो उसे क्या बोला जाता है? दैट इज योर नेक्स्ट टर्म लॉकआउट. लॉकआउट दैट इज डिफाइंड अंडर सेक्शन 2I. दिस 2L, which says a lockout means the temporary cessation or temporary closing of a place by the employer or the supervisor of the work to refuse the work by the employees to discontinue from working for a number of persons for a period of time, that is called to be as a lockout. That means to say, जब एक employer अपने employees को वर्क पे आने के लिए मना कर देता है या डिसअलाउ करता है फॉर अ टेम्परेरी पीरियड ऑफ टाइम, दैट इज कॉल्ड टू बी एज योर लॉकआउट. Let's understand the difference between the term strike and the lockout. Now, strike is a temporary closure of the place of the employment initiated by the employees, whereas lockout is a cessation of the work by the body of the person employed in the industry. Strike is a weapon in the armor of the working class to fight collectively to pressure the employer in the weapon to safeguard their rights and interests. Whereas the lockout is an act which has been done by the employers in the industrial establishment, which is with temporary closing down, where they take it as a defense when the workers are not fulfilling their duties in a proper manner. So when an employer is closing the business for a temporary, it is called to be as a lockout. When the employee are not going to come for the work, they are called to be as a strike. Now, at times, strike can be defined into your illegal strike and legal strike, where if the strike is not done in an ethical manner, where priorly even for the strike and lockout both they are required to give a proper number of notice. If they have not given the notice, such kind of strike is not to be called as a proper strike, and that's why it can be called as an illegal strike or illegal lockout. The next term when we are talking about is now layoff. Layoff means the failure, refusal or inability of an employer on account of storage of coal or power of raw material, of the accumulation of stocks or a breakdown of the machinery or any other natural calamity for any connected reason to give an employment to the workman whose name is being there on the muster in the industrial establishment and who has not been removed from his work, then it is called to be as a layoff. जहाँ पर अगेन टेम्पररी पीरियड के लिए जब एम्प्लॉयर काम नहीं दे पा रहा है बिकॉज एक्सेस स्टॉक पड़ा हुआ है या रॉ मटेरियल्स नहीं है, देन एट दैट पीरियड ऑफ टाइम इट इज कॉल्ड टू बी एज ए ले ऑफ. अच्छा, ले ऑफ के टाइम पे भी एम्प्लॉयर इज रिक्वायर्ड टू मेक द पेमेंट टू द एम्प्लॉइज इफ द एम्प्लॉइज आर ready to come for the work and they are ready to work for a substitute work if they are been given, and for that the employer is required to make a payment for the same, and the payment can't be equal to the amount but it can be lesser amount also. So that is called to be as a layoff. Now the next term is when I'm talking about is retrenchment. Now the retrenchment means to the termination, removal by the employer of the service of a workman for any reason whatsoever otherwise than a punishment inflicted by way of disciplinary action but does not include. Retrenchment का मतलब होता है सिंपल टर्म, जहाँ पे इट मीन्स जहाँ पे एक एम्प्लॉय को निकाल दिया गया है डिसिप्लिनरी एक्शन के लिए बिकॉज वो काम पे नहीं आ रहा था, प्रॉपर नहीं आ रहा था, काम जानबूझ के नुकसान कर रहा था, ऑल दोज रीजंस के कारण इफ द एम्प्लॉय हैज बीन रिमूव्ड, देन that includes, it should not be equivalent to a voluntary retirement of the workman. It should not be retirement of the workman on the reaching of the particular age. It should not be or termination of the services of the workman on the ground of continued illness. उस कारण से नहीं होगा. उसके अलावा कोई भी कारण से अगर रिमूव कर दिया गया है then it is called to be as a retrenchment.